welcome everyone to the Separation of Powers panel. My name is Josh Chaffetz. I'm at Georgetown Law School, and we have three very exciting papers that are going to be presented today. So first, we have Peyvand Adutz from the University of Virginia presenting Separation of Powers Avoidance. Then we have Andrea Katz from Washington University and Noah Roosevelt from NYU presenting Becoming the Administrator-in-Chief, Myers and the Progressive Presidency. And last but certainly not least, we have Aaron Nielsen of BYU and Chris Walker from Ohio State presenting Congress's anti-removal powers. Each author or set of authors will have 15 minutes to present their paper. Then I'll take about 10 to 12 minutes to say a little bit about each of them. Then I'll give the authors themselves the opportunity to say a few words if they want to about one another's papers, and then we'll open it up for questions at the end. The organizers have asked that if you have a question, just type the letter Q into the chat box. It would be great if everyone could do that instead of some people using raise hand and some people doing that, just so I can see sort of what order people actually wanted to ask their question in. Oh, and I've also been asked to remind you, please only ask one question rather than raising your hand and asking 6 questions, just so we can get through as many questions as possible. So with that, I am going to turn it over to Peyvand.
Hi, everyone. I'm so grateful for the opportunity to present this project today before and alongside friends and future friends who I so admire. And thank you, Josh, for engaging with this work outside of this room. Also, I'm looking forward to your comments. So one thread of my work is guided by a single question. How does litigating separation of powers inform the content of separation of powers? And I've broken that down into different spheres. And my last project, Enforcement Lawmaking and Judicial Review, focused on lower courts, district court, courts of appeal in an effort to understand their unique role in preserving the separation of powers. And as I read literally hundreds of district court opinions in separation of powers cases, ranging from jurisdictional litigation to discovery disputes to merits opinions, I began to see that certain doctrinal threads seemed warped. And this project, Separation of Powers Avoidance, is my investigation into those warped doctrinal threads, their content, their origins, their motivations, and their consequences. So I start with the premise that federal courts aren't neutral arbiters of the separation of powers. When we go to court to adjudicate a separation of powers dispute, judges are both expositors of the separation of powers and participants in the separation of powers. And sometimes this participation distorts the content of the constitutional law that results from these opinions. And in this paper, I'm talking about one particular mode of distortion, and that's when courts choose to avoid thrusting themselves into the separation of powers fray. It's a practice that I call separation of powers avoidance. Ultimately, I argue that we shouldn't over-rely on these warped constitutional law principles outside of federal court, and in particular in negotiations between the president and Congress, when those negotiations occur wholly outside of federal courts, and when we, the people, are asked to assess whether we like what's going on among our elected officials. Is what they're doing consistent with what we think the Constitution has to say? So I'm going to start today by briefly discussing what separation of powers avoidance is, and then I'll very briefly mention the 3 models that I think it takes. And I'm going to spend much of today mapping the content, origins, motivations, and consequences of just one doctrinal category that I think is warped by separation of powers avoidance, and that's discovery of the president and executive privilege. So what is separation of powers avoidance? Much like the canon of constitutional avoidance that directs courts to favor statutory interpretation that does not raise a constitutional question, I think separation of powers avoidance is a similar judicial principle where courts stay out of the fray of getting into a separation of powers dispute. And the ultimate payoff here is just as the statutory canon of constitutional avoidance can distort underlying statutory text, separation of powers avoidance can distort underlying constitutional doctrine. How do courts implement separation of powers avoidance? It's not as straightforward, I think, as the canon of constitutional avoidance. So in the paper, I talk about 3 different models. And I apologize because the draft wasn't totally clear, because at the time that I wrote it, I wasn't totally clear on what the terminology should be, what my evidence was. But I think there are roughly 3 categories of avoidance. One model I call the embedded model, is where courts interpret doctrines through the lens of separation of powers avoidance, and that reflects back into the underlying doctrine. We'll talk about that today when I'm talking about discovery. Second, I call the process model, which is where courts do the opposite. They add an additional separation of powers step to an analysis. So before you get to doctrine, ask yourself, what's the impact here on the separation of powers principles? Sometimes we see courts of appeal or the Supreme Court vacating a decision below, not because it's wrong, but because they didn't adequately interrogate the separation of powers implications of it. It's what I call your decision wasn't separation of powers-y enough. And finally, I think there's this fortified model where courts fortify existing jurisdictional doctrines to avoid a separation of powers conflict. So there are fortified doctrines of congressional standing that I interrogate a little bit in the paper. So I have a single goal today, and that's to pique your interest through the thread of discovery of the president and executive privilege. And I think that's a tall order, because outside of a very small group at the Civil Procedure Conference, when I say discovery, I lose 80% of the room. But this is the first talk of the day, so I hope you're still with me. A couple of months ago, President Biden waived executive privilege over certain materials related to the January 6th insurrection. And he agreed to turn over documents to permit individuals to testify before Congress. But nonetheless, we saw witness after witness claim to be cloaked in President Trump's executive privilege and refusing to testify. And as these challenges began making their way into court, I got a phone call from a reporter asking me to talk about what this meant for the future of executive privilege. I think he was fishing in our discussion for me to say, if President Trump wins, then nothing can ever, pierce the veil of executive privilege. Or if President Biden wins, the whole world is over. And I didn't take the bait. Instead, I started off with this case, Cheney versus District Court, and I started telling him that courts sort of avoid the fray, and I totally lost him. I wasn't quoted in the article, and I think that's fine, because I'm going to say that today I have an audience here who might be slightly more interested in this case than the ordinary readership of this periodical. So let's start with Cheney, and the background is that Judicial Watch is seeking discovery from Vice President Cheney concerning this advisory committee or possible advisory committee that's set up within the Bush administration. And the vice president doesn't want to turn any discovery over, and he doesn't even want to claim privilege over the materials. He just wants this case to go away and for nothing to happen. And the district court does something that's in ordinary civil litigation, totally legitimate. It says, claim your privilege here or turn over the documents. But the vice president doesn't do either. He petitions the Court of Appeals for mandamus relief, and that petition ultimately finds its way to the Supreme Court. And we get what becomes the bedrock of executive privilege, this Cheney versus District Court mandamus case that also, against the backdrop of some Nixon opinions, creates what we now know, what we appreciate as executive privilege. And the court says once executive privilege is asserted, co-equal branches of government are set on a collision course. The judicial is forced into the difficult task of balancing the need for information in a judicial proceeding and the executive's Article 2 prerogative. This inquiry places courts in the awkward position of evaluating the executive claims of confidentiality and autonomy. So what does the court do? It vacates the discovery order and remands with the instruction that courts must sua sponte narrow discovery orders of the president to avoid the president having to claim executive privilege at all. In other words, lower courts are here doing the work. And I argue that this requirement that courts sua sponte narrow the discovery orders creates a protected space beyond executive privilege in the federal courts. It's not the true limit of what executive privilege requires, but instead some protective moat based on what courts have to do to avoid the awkward position of telling the president to turn over documents. So what motivates the court to do this? I think the language in the opinion is quite clear that they're trying not to be in a fight with the president over documents if they don't have to be. So let's do something to protect ourselves and not go there. Let's not give the president the chance to defy our orders by first doing something to narrow what's going on, what the dispute is. How can we stay out of it? At least that's the argument that I'm trying to make in this paper. And I'm marshaling some evidence about some sort of awkward twists and turns in different opinions, different cases where courts order the president to turn over particular materials and the Department of Justice refuses to do so. And we see this over and over in district court cases having to do particularly with national security. And I think that there are rule of law concerns for this, but this is what's formed the basis for my intuition at this point, which I'm hoping to explore a little bit more fully in future drafts of this article, that courts are really here trying to protect themselves from something, from the president telling them they don't have authority over something, or from the president setting aside judicial determination. But today, I just want to talk about what this all means. When we see separation of powers avoidance, at least I can't unsee it. So how should I change my behavior, whether it's a good or bad thing that courts engage in separation of powers avoidance? What should that impact? And I think that there are two categories where the evidence is clear that we shouldn't be relying on doctrines that are warped by avoidance. First are negotiations between Congress and the president that occur exclusively outside of federal court. And the second is when we're called on to evaluate the constitutionality of what our representatives do. So I think that a lot of constitutional law is determined not by courts, it's determined by practices. How often is there conflict between the Congress and the president? How often what kinds of mechanisms do they have in place to negotiate with one another? And much discussion, it goes through this process known as accommodation. So when Congress subpoenas someone in the White House or tries to get particular sorts of documents, the two engage in the process of accommodation. And the president says, I'll turn over this subset of information to you. And normally that's the end of the story. It's what Chief Justice Roberts calls the hurly-burly of negotiation between the Congress and the president in the Mazar's opinion. And I think that even in this process of accommodation, which is supposed to occur completely outside of the federal courts, we see judicial doctrine creeping into the negotiation, in particular through OLC memoranda. And one of these memoranda that I write about in the draft is this memo on congressional oversight of the White House, where OLC relies on Cheney to advance a really fortified claim of executive privilege. In the draft, I talk about it at length, but here I just want to emphasize one point. Because congressional inquiries also implicate autonomy and confidentiality, OLC says that the separation of powers concerns recognized in Cheney support significant limitations on the timing and scope of congressional oversight inquiries directed at the White House. If anything, OLC says, the concerns underlying the court's decision in Cheney apply with even greater force to congressional inquiries. Congress is the president's constitutional rival in a manner distinct from the judiciary. I think this is exactly backwards. In Cheney, the judiciary is motivated by a desire to keep out of the fray. That might be a legitimate choice for courts to take or not, but if Congress wants to act in a rivalrous fashion, then it should be able to decide for itself to act in a rivalrous fashion. That's a particularly legitimate choice for a co-equal branch of government to make, free from the choice that the judiciary makes. And I argue that that's what we should do. We should take the judiciary out of these negotiations from the start. But OLC is not the only one relying on over-relying on judicialized language. I started today with a story about a reporter calling me, trying to get the story on what the courts had to say about executive privilege. And I think that regardless of what the courts hold, if they rely in any substantial measure on cases like Cheney or its progeny, then that should have little to no impact on our assessment of whether Congress, President Biden, or President Trump is in the right here. The only thing we learn is what the judiciary can or must do in the conflict, and it would be a mistake for we, the people, to take anything more out of these opinions. This is not the only area. Discovery is sort of in the moment now, and that's why I talk about it today. It's easy to trace it from the beginning to end of the paper in a way that I hope is at least compelling to you to be interesting. But I don't think that this separation of powers avoidance only impacts executive privilege and discovery disputes. There are impacts in Congress's ability to participate in litigation and the substance of those suits when courts decide that Congress can participate or can't. It impacts the substance of mandamus cases involving the government. And those are the stories that I want to develop in this project. Thanks so much for engaging with me. I'm going to leave it there, hopefully without losing you. Sorry for starting your day with discovery, but maybe it's interesting.
I certainly find it fascinating. Thank you so much, Pavan, for that. Next up is Andrea Katz and Noah Roosevelt.
Okay, thank you, Josh. Thanks everybody for being here this morning. It's such a blessing to have folks engage with your work, so we're really grateful. So we're gonna split our time into in half, so I'll try to be expeditious here. This project is a result of Noah and my long-term shared interest in the institutions of the American presidency, and specifically for this project in the doctrine of the unitary executive. This doctrine, as everybody in here knows, is one of relatively recent vintage, which has become one of the calling cards of the Roberts Court's jurisprudence. The core of the idea of the unitary executive is as follows. So by dividing the government into three branches, the theory goes, the framers intentionally set up the president as the head of the executive branch with unique and particular responsibility for carrying out the law. The corollary to this, all non-judicial, non-legislative actors in government must report to the president as administrator in chief. And for Congress to interfere with this unbroken chain of command, i.e. by shielding officers from the president through statutory means, is unconstitutional. As we put it in the paper, from the fact of three separate branches, unitary executive theory infers a constitutional mandate of unimpeded presidential control over the administrative state. Okay, that's the theory. All right, so today's Unitarians tell us that this idea comes from original constitutional principles inherent in our constitutional design. In reality, we found that all of the Supreme Court's recent unitary executive cases, a lot of folks in here are familiar with Free Enterprise, Saylor Law, Collins, just to name a few, seem to point back to a single case as a legal authority for this model, the 1926 case US v. Myers. So our project kicked off with a return to this case in the hopes of excavating the model of the presidency that it does lay down. Now, Myers itself, talking about arcane matters of legal doctrine that people aren't excited about, turns on a set of facts that seem undisputably arcane 100 years later. This is a dispute arising late in the Woodrow Wilson administration. The president fires a postmaster fourth class. At the time, under the law on the books, to fire that individual required the Senate's participation alongside the president's. Now, obviously, the Constitution specifies the procedures for appointment of federal officials, but it's silent on who removes them. So the question that arose in Myers was, could Congress legislate its own participation in the removal of federal officers? That opinion, written by Chief Justice and notably former President William Howard Taft, concluded that Congress had no power to do so under the Constitution. So guiding Taft in this very lengthy opinion is a lot of history. I just want to touch on two historical points that he makes. One is the famous debate of 1789, in which the first Congress of the United States discusses the bill that would eventually create the Department of Foreign Affairs, the State Department today, right? And specifically whether that act should provide that the secretary was removable by the president. In the end, as we know, the legislators scrapped this language about removal, presumably because they believed that the power to fire the secretary already lay with the president. But does the episode clearly lay down that rule? From there, Taft's opinion covers several decades of history intended to show a separate point, which is that Congress had never in its history presumed to make a president's ability to fire officials depend on the Senate's own consent, at least not until Reconstruction, where in Taft's retelling, a rambunctious, unified, radical Republican Congress does battle with Andrew Johnson over hiring and firing, leading eventually to the Tenure in Office Act, a relative of which statute the Myers Court is called on to review. So Taft concludes that Reconstruction is kind of an anomalous period in American history, and that with this removal law, Congress had overreached. So Myers is a 6-3 decision that was controversial the day that it was handed down, with contemporary critics writing occasionally to savage Taft's history. As we dug deeper into Myers, that is to say the origins of the case, the separation of powers jurisprudence that preceded it, the model of the presidency that Myers does lay down, we came to a similar conclusion. Not only were the critics right in 1926, but more pertinently, in 2022, Myers itself does not provide support for the idea of the unitary executive, and this is for a couple reasons. Number one, Myers is not properly originalist. Myers instead uses a historical developmental mode of interpretation that emphasizes that years of mutually agreed upon practices between Congress and the president effectively make constitutional meaning. This mode of precedential argument essentially is quite far from the textualist approach favored by the bench today. Second, Myers itself broke with decades of prior cases on the separation of powers to constitutionalize what we're calling a new understanding of the presidency, the progressive president, which is entirely based on late 19th and early 20th century developments. On our theory, the progressive presidency has two core elements: one, public opinion leadership, and two, presidential administration that we claim could not be found in prior scripts of the office. In other words, Myers, we're saying, constitutionalizes a specifically 20th century president, not an eternal, unchanging blueprint of the office drafted in the 18th century. I see that I'm running a little bit short on time, and I want to make sure that Noah gets his full say. So I want to just say one more thing. We don't say a ton about the originalist presidency in this version of the paper, and I think we are being increasingly confronted with a realization that we must. So our takeaway about that is, do we hope to persuade an originalist that there is a problem with relying on Myers to support a unitary executive? Yes, we do hope to do so. And that's not just because Myers codifies a different presidency from the one it is represented to be represented today, but because the unitary executive is a non-originalist president itself. So putting it in a nutshell, the unitary executive is indeed based on a progressive model of the presidency, and the progressive presidency is far from an originalist one. Why? Specifically because the originalist presidency is fundamentally a constitutional officer, not a political one. So the idea of a president using public leadership or some claim to represent the popular will as authority to make policy independent from Congress is incompatible with original design. So that's our claim on that, and I'll turn the rest of the time to Noah.
So thank you, Andrea. So how can we see this novelty of Myers that Andrea just laid out for us? Well, one way to do it is just to juxtapose it with the removal cases that came before. So prior to 1924, when Myers is first argued, there had been several cases involving questions about whether an officer in the executive branch could be removed. And at least before the 1890s, it seems like they're all handled the same way, which is through a careful statutory analysis and without any sense that the case implicates fundamental questions about the organization of the government or the role of the president in the state or the fundamental nature of democracy. So if you'll indulge me, if we take the case of Perkins from 1886, we can really see this. So Perkins is part of a line of cases from that time, which have to do with reorganizing the United States Navy. Basically, after the Civil War, there was a big push to modernize the US fleet and embrace these steel ships in place of the wood sail-based fleet they had before. But there was a really entrenched group of old line sailors and officers who resisted the change. Eventually, Congress does manage to push reforms through, one of which is to change the way that promotion into the Navy from the Naval Academy works. It used to be that promotion into the ranks of the Navy was as a matter of right for Naval Academy graduates. You just went in, regardless of your merit or the needs of the fleet. But now it would be based only on the needs of the fleet, and you would be promoted in order of merit. Now, it was totally clear how this law would apply to new cadets. They would only go in if there was need and if they were good enough, and all that. But the law did leave a bunch of cadets in the lurch, namely the ones who were arguably just on the cusp of entering the Navy. So maybe they were already in the Navy and so therefore enjoyed a tenure protection under this law that was already on the books. Or maybe they weren't yet in the Navy. Maybe they were still undergraduates, even though they were serving on ships. And in that case, they wouldn't be entitled to a position at all. So this is what leads to a whole bunch of lawsuits, including the lawsuit in Perkins. Okay, so here's the part of Perkins that matters to us. When the Perkins suit goes forward, the Court of Claims and then the Supreme Court follow practices from earlier cases and say, well, the sailors in question are definitely in the Navy. The government then argues that even if they were in the Navy, the Secretary of the Navy had independent power to remove them. And the court says, well, actually, that's a statutory question. And here the statute just doesn't give the Secretary of the Navy that power. Now, that principle that this is a statutory question goes back at least to an 1839 case captioned Ex parte Hennen. Some of you may be familiar with that caption because there's this bit in that case that everyone loves to paraphrase about how the power to appoint implies the power to remove. First off, that's just not what the case says. The actual quotation is, quote, in the absence of all constitutional provision or statutory regulation, it would seem to be a sound and necessary rule to consider the power of removal as incident to the power of appointment, end quote. So even in that case from 1839, it's at most a kind of default rule. But in any case, the part of that opinion that really matters is about the source of law. So Hennen stands for the proposition that, quote, the execution of the power to appoint and remove depends upon the authority of law and not upon the agent who is to administer it, end quote. And this idea, right, that we're thinking about the source of law makes a ton of sense for a world of spoilsmen and party presidents. The whole structure of the government then is really about providing patronage appointments for party machines. The president of the 19th century matters most for its ability to fulfill congressional appointment needs. Now, of course, that idea of what the government is for changes over the course of the 19th century. We get the professionalization of the civil service, the development of an independent bureaucracy, and with that, we start to see the emergence of a new role for the president. This is what Andrea described as her and my shared interest in the Progressive Presidency. But, and here's the crucial point, right? The statutory law has not been comprehensively reformed, even as this new president is emerging. We get distinct interventions, the Pendleton Act of '83, the repeal of the Tenure of Office Act in 1887, eventually the Budget and Accounting Act of 1921, but we still have all this old case law and all these old habits on the books. And with those old habits in mind, we can see how much of a break Myers really is, right? As we note in the paper, the court could have decided Myers without reaching the constitutional question in the same way that it had handled a whole slew of earlier cases like Perkins. I won't take you through the doctrine now. I do a little bit in the paper. We do a little bit in the paper. But the logic of two of the prior cases, Parsons and Shurtleff, gave the court a way to handle Myers statutorily and reach the same result if they wanted to. But Taft just decides not to, right? He's simply not interested anymore in building on the jurisprudence of a world in which the executive is a creature of Congress. He wants to make a world in which the government is going to be a creature of the president. And we see that in his reasoning, the way that he cabins the previous jurisprudence, goes right to the text of the Constitution, and defends the whole thing on the basis of the progressive political theory of presidential representation that Andrea laid out in the first part of our presentation. So let me just end in this last minute with 2 quick points and 2 quick questions. So the 2 quick points, right? First, and this is just going to underscore something Andrea said before and just kind of stick it in, right? Even as Taft builds this presidentialist vision, he sticks to standard progressive tropes about expertise and professional government. So he says, this new approach is not going to threaten the civil service. We're still going to be able to protect Article I adjudicators. So even if you're seduced by Taft's vision, it's very different from the contemporary court's arguments in Saylor Law and Arthrex. And second, there's an irony here if you're thinking about it from the perspective of constitutional interpretation. What we've got is an opinion that updates the law to changing institutions. That sure sounds like living constitutionalism to me. And yet, as Andrea pointed out, the opinion is often invoked as a kind of originalist ruling for the unitary executive. So one payoff from all this is if you put Myers into context, you see that the allegedly originalist foundation of unitary executive theory is neither originalist nor unitary. Okay, so the two questions are just about how we should tell the story, and then I'll conclude, or then I'll be done. One, as you can see from the paper, Andrea and I have structured it as we sort of did in this presentation by talking about institutions first and then doctrine, but we've been thinking that maybe we should be trying to interweave those stories more. And that takes us to the second question, which is about how much theory we need. As we've told the story now and shared it with you in the paper, we've left most of our theory out, but we do think that there is a deeper story here about the law of offices and the relationship between scripts of office, public law, and institutional development. And one question that we have for you is just how much of that story we need to tell. The paper is already very long, as you can see, so we're eager for advice about where we can cut. So I'll stop there. Thank you so much.
And thank you so much to both of you. And now for our final paper presentation, we're turning it over to Aaron and Chris.
Thanks, Josh. Well, it's great to be here with you all. This paper comes out of an amicus brief. Back in the fall of 2020, Aaron was appointed by the Supreme Court to defend the constitutionality of the Federal Housing Finance Agency when the Trump administration refused to defend it. And he enlisted me as co-counsel, and we spent the fall drafting and researching for the brief and then preparing Aaron for argument. And I think he did a great job in December of that year. But we learned two things from that experience. One is, well, we lost. The Supreme Court struck down as unconstitutional the for-cause restriction on the president's ability to remove the head of the FHFA. The holding was sweeping, and it's fair to say that stare decisis is the only barrier to the Supreme Court overruling Humphrey's executor. It's a seminal decision that allows Congress to require good cause for the removal of the heads of multi-member independent agencies. Indeed, some scholars are already predicting the end of independent agencies. And the second thing that we learned, and this is the core point of our paper, is that Congress has other tools that it can use to influence the president's removal behavior to create at least a measure of agency independence. In the paper, we call these tools Congress's anti-removal power. They're not new. They've been around since the founding, but they've been largely overlooked because we focus so much on Humphrey's executor and the role of courts in ensuring agency independence. And I want to say at the outset that these tools aren't as strong as statutory removal restrictions. Happy to kind of talk through that more. This isn't an argument that we're going to be just fine with Humphrey's executors if it is overruled. But these tools do allow Congress to counteract the president's removal power by making removal more costly to exercise in the real world, and thus by discouraging the president from exercising it unless there is a really good reason. So I'm going to spend the talk today I want to make 2 points. One, I want to introduce Congress's anti-removal power and its toolkit that it has to strengthen that power. And then I want to turn to one area where Congress can and should use that power today, and that's in the context of the decisional independence of agency adjudicators. And I probably need to start with a little bit of basics here, although Andrea and Noah covered some of this. But when we think about agencies, we can largely put them into 2 buckets: executive agencies like the State Department or Justice Department, and independent agencies like the Federal Trade Commission. And the key difference is that when it comes to executive branch agencies, the president can remove the head of the agency at will, but that's not the case with independent agencies. Congress, by statute, has instituted removal protections when it comes to independent agencies. And Congress has created all sorts of independent agencies and has even created independent officers within executive branch agencies. And it does so because Congress has determined that those agencies or those agency officials should have some insulation from presidential politics. So the classic examples like the Federal Election Commission or financial regulators, the Federal Reserve. And since Humphrey's executor, 1935, it's a case that upheld the constitutionality of the Federal Trade Commission. The Supreme Court has expressly blessed this arrangement of allowing Congress to provide some removal protection. The Roberts Court, however, has embraced Justice Scalia's more unitary executive view that Noah and Andrea were discussing, that the president should be able to more freely remove anyone within the executive branch. In Say the Law 2 years ago, for instance, the Supreme Court in a 5-4 decision struck down the leadership structure of the Consumer Financial Protection Bureau because it was headed by, it was an agency that exercised significant executive authority, and it was headed by a single director that was removable only for cause. And then last year, in the case where Aaron was court-appointed amici, the Supreme Court went even further in striking down the leadership structure of the Federal Housing Finance Agency. I note that Justice Kagan only concurred in the result out of stare decisis, but she refused to join the decision because the court refused to provide any limiting principle. Justice Alito, writing for the majority, would not even tell us whether the chair of the Federal Reserve, the head of the Social Security Administration, or even members of the civil service, all of whom have some tenure protection, are constitutional. And we've already seen the impact of that in the executive branch. 2 weeks after the decision, the Justice Department's Office of Legal Counsel opined that the president could fire at will the head of the Social Security Administration, and President Biden the next day fired him. Many scholars are already predicting that Humphrey's executor is next. I think the conventional view is that if Humphrey's executor is overruled and statutory removal restrictions are eliminated as one of Congress's tools, that's the end of independent agencies. And this is where Congress's anti-removal power comes in. When we were researching and drafting the brief, we realized that the familiar debate over Humphrey's executor had overlooked something really important: whether or not the president has a removal power under the Constitution. Congress definitely has an anti-removal power. It has the ability to raise the president's costs of removal so as to discourage the president from removing an individual in the first place. And we find this power primarily in the Appointments Clause. If the president can fire the head of an agency, the president has to get a new one confirmed by the Senate. Because the president does not know if the Senate will confirm a replacement that's better than the incumbent, the silent operation of the clause, in Hamilton's words, is that the president often will not fire that incumbent in the first place, thus creating what he would call stability of administration, or what I might call at least a measure of decisional independence. But this anti-removal power isn't just limited to the Appointments Clause. It's found in other tools that Congress can use to raise the cost of removal on the president. I want to just talk about a couple of them. We illustrate and kind of talk about even more in part 3 of the paper, including in a table at the end of part 3, if you're kind of looking around there. And we divide these tools into soft tools, hard tools, and anti-evasion tools. I just want to talk about a few in each of those categories. So in the soft tool category, when we were researching the brief, we find it somewhat remarkable that Congress at times imposes reason-given requirements on the president. They do that with respect to the control of the currency and with respect to inspector generals. In other words, they say to the president, you could remove those individuals at will, but if you're going to, you have to provide Congress and the public with the reasons for why you remove them. We suggested another soft tool that could be coupled with this is that Congress could require a congressional hearing when there's a removal, or perhaps only when there's a removal without providing a statutory required reason or a statutory required good reason. This isn't the same or as good as an Article 3 trial, where you have the third branch of government declaring that the president's conduct is unlawful, but it is still another way of kind of having a trial in the court of public opinion. Again, raising the removal costs to discourage the president from moving that official in the first place. When it comes to the hard tools, the key tool is the filibuster. For certain agency officials that Congress wants to create a greater level of independence, Congress could raise the filibuster requirement. Do that either by Senate rules, perhaps by statute. Happy to kind of talk through the constitutionality in a second during the Q&A. And one of the great things about these tools is Congress can modulate how they use these tools based on how much they care about independence. Perhaps for the head of the Fed, it's 3/4 if the president fires the current head without cause. Doesn't provide a good reason for the firing. But for others, you might have a much lower threshold. You can also couple the filibuster cloture vote requirement difference with the other tools, such as the failure to provide good reasons. Maybe it only is triggered then. And the key thing with all of these soft and hard tools is that Congress can always do this on the back end. This is Josh Chaffetz's separation of powers, Congress's constitution. But what we're trying to argue is they should do this on the front end as pre-commitment devices. In other words, to send the message before the president fires someone that these are the rules of the road when it comes to these types of independent agencies. Now, the last set of tools are really important because the president has a number of ways to evade having to go back to the Senate to get a new Senate confirmed leader of that agency. The president can try to use a recess appointment. The president can and does a lot use acting officials, and Joseph O'Connell and Nina Mendelsohn have done a lot of important work in that area. And they can also subdelegate within agencies. And these are all areas where Congress can also play a good role. And the great news here is that the Supreme Court in all three of these areas in recent years has been very pro-Congress. So with respect to actings, for instance, Congress could decide to reform the Federal Vacancies Reform Act, let's just call it the Vacancies Act, and do some of the stuff that Professor Mendelsohn has suggested by making that the acting can serve for a shorter period of time, or that the group of individuals who could be considered actings have to have served a longer period of time at the agency to remove those who may be more loyal and more recently added to the agency. I'm happy to talk through more of these kind of anti-evasion tools in the Q&A, but I think these are really important if you're trying to kind of create the right balance for the president not to fire an independent agency official, that you cut off some of the avenues for the president to bypass Senate confirmation. Now, I want to note that none of these tools are going to guarantee agency independence. Like, no president is going to refuse to fire the Secretary of State if they have a major policy disagreement. Like, this isn't an on-off switch. Instead, the goal of Congress of anti-removal power is to increase the president's cost of removal for positions where we really care about independence, such as the head of the Federal Reserve, financial regulators, inspector generals, and the like. And I just want to end with my last few minutes by turning to agency adjudication. And the common response, and I'm guessing a lot of you are already thinking this, is how could our toolbox like remotely work in this Congress? How could it work in divided Congress? How does it work in unified Congress? Isn't this really just about separation of parties, not separation of powers? I have a few responses. The first is, I think some of these tools actually work quite well in divided government, as well as in unified government. The soft tools in particular give the minority power a lot more voice in a unified government. I'm happy to kind of talk through that more in the Q&A. The second is that we're talking about the Constitution here. So even if this Congress isn't going to act, that doesn't mean that's always going to be the case. And the third is that there's at least one area where the anti-removal power should be used today and can be, and that's in the context of agency adjudicators. And a lot of my research in recent years has focused on agency adjudicators. Again, I'm at a conference on constitutional law. We're going to focus a lot on those 800 or so Article 3 judges that are Senate confirmed. But if you really care about the federal judiciary, there are more than 12,000 agency adjudicators that adjudicate millions of cases across the federal administrative state, ranging from Social Security and veterans benefits to patent rights and immigration. And with Congress, when it enacted the Administrative Procedure Act, it went to great lengths to preserve the decisional independence of these agency adjudicators. It made their hiring apolitical and based on merit, and it granted them tenure protections from removal and discipline based on politics or policy. If you read the cases that Noah and Andrea mentioned, the recent ones, Justice Breyer has repeatedly warned that the decisional independence of agency adjudicators is also at risk by the unitary executive move. Indeed, we've seen in recent cases that the court has said in Arthrex that the head of the agency has to have final decision-making authority in adjudication. They've also held that the agency head has to be able to appoint the agency adjudicators, that they can't be appointed through a less political, more merit-based process. And the big case that's going to make its way to the Supreme Court soon, and just last month they dodged it, is whether the agency head also has to have the ability to remove for cause the head of agency adjudicators. And I agree with Justice Breyer that these developments threaten decisional independence. If an agency adjudicator is going to be worried about being fired for not agreeing with the politics or policy preferences of the agency head, it's fair for parties to wonder whether they're going to get a fair shake, whether that adjudicator is going to be based on decision on law and facts or out of the fear of being fired. And I hope you can see that Congress's anti-removal power has a lot of purchase in this context. And this is a context where there's a lot of bipartisan support for decisional independence. Maybe for some of these adjudicators, the Senate may decide to make them Senate confirmed. I think that might be a good place to do that is with the Board of Immigration Appeals. or with the Patent Trial Appeal Board of the appellate bodies within agencies. Now, that's not going to work for 12,000 agency adjudicators. That's not our argument. That's not a good idea. It's just not politically feasible. But for the rest of them, our soft tools work really well. Congress should require the agency head to provide reasons for the firing of an adjudicator, to provide good reasons to Congress. Congress should require a hearing when an agency head fires an adjudicator, or at least fires an adjudicator without providing a good reason. At that hearing, the agency head would testify. So would the fired adjudicator. And other witnesses would be called, such as the head of the adjudicators union, and allow them to kind of publicly air what happened. And the result here is that although the agency head still has the ability to remove agency adjudicators, it will often end up being too costly. Indeed, I think at least in the agency adjudication context, it'll replicate a lot of what we had before Lucia and before we had kind of this more unitary executive turn, where agency adjudicators would only be fired for cause when there's a real merit-based reason for them not being in the place. So I think I'll just stop there, and I look forward to hearing your comments and questions.
Thank you so much. So those are three incredibly deep and rich papers. So I have a lot of thoughts about all of them, but I'm going to try to limit myself to just about 12 or 13 minutes or so talking about all of them combined. So first of all, on Pavan's paper, I really like this piece. I really like sort of where it's headed. I especially like your focus on the harms that judicial doctrine can do when transported to non-judicial contexts, right? And this ties into a sort of larger literature about sort of the creep of judicial language, which I think can be really pernicious. I'm a little confused, though, about the framing as avoidance in particular, because my read is that the courts have basically been inserting themselves more and more in recent decades into disputes between the other two branches, right? So, before Watergate, for example, the House of Congress had never once gone to court seeking to enforce a subpoena to the executive, but it's happened with increasing frequency since Watergate, especially since the Reagan administration, and especially with the first three presidencies of the 21st century, right? It's been a major conflict in the Bush II, Obama, and Trump presidencies have been fights over subpoenas from Congress playing out in court. And as I've argued in my own work, just by the way that the courts pace these cases, essentially they have resolved them in favor of the executive, even when the sort of final outcome on paper might look like it is a win, or at least a partial win for Congress. Relatedly, as the other two papers on this panel have shown, right, Congress has been very aggressive, especially in the last decade, and is becoming even more so in disabling Congress from structuring the executive in the way that Congress might wish to do. Substantively, we've seen the rapid growth of doctrines like the major questions doctrine that serve as sort of a de facto non-delegation doctrine. And it seems entirely plausible that we're about to get a beefed up version of the actual non-delegation doctrine in the Supreme Court. Likewise, you talked quite a bit about Cheney, both in the draft and in your remarks. Cheney strikes me as best understood as a substantive expansion of the scope of executive privilege, right? If the Supreme Court is saying to a district court, you need to preemptively narrow your discovery order such that the executive couldn't raise a claim of executive privilege if it wanted to. Perhaps the best way to describe that is simply executive privilege is now much broader than it used to be, right? Because if you can't get discovery against the executive, that strikes me as a pretty good, analysis of what the substantive scope of executive privilege actually is. So it seems to me that sort of really what binds these together isn't so much what I would understand as being avoidance, which sort of carries the connotation of sort of shrinking away from conflict, but rather substantive resolution of these conflicts in ways that are first and foremost executive empowering, secondarily frequently judiciary empowering, but the sort of thread running through all of them, I would say, is that they're losses for Congress, right? They're attempts to sort of take away Congress's power to structure the functioning of the other two branches, or to put it differently, attempts to sort of divvy up governing primacy between the executive and the judiciary. And I thought something you said in your sort of remarks was really interesting. You said that courts here are trying to protect themselves from something, right? That strikes me again, not so much as avoidance, but maybe as, you know, self-protection, right? Judicial assertiveness of a certain kind. So that was sort of my main thought on that paper. For Andrea and Noah, another fantastic piece, especially sort of for me, it really plays to my priors in bringing APD sort of even more fully into the heart of constitutional scholarship, and especially love your focus on the sort of dynamism and contingency of institutional arrangements. On the contingency point, I hadn't really thought before in thinking about Myers about why it is that Wilson doesn't just nominate a replacement. So the fact that you know, Wilson's illness figures so prominently in the story, right, I think is a great example of the way that contingency sort of plays with path dependency rather in thinking through institutional change. I also would note that this piece seems to partake of a recent boomlet in William Howard Taft scholarship, which I did not see coming. So I think that's fascinating. And finally, more substantively, I love the sort of reframing of Myers as a sort of creature of the progressive presidency, because it's one of those reframings that sort of seems counterintuitive at first and then becomes sort of more and more plausible the more you get into it. But I do have sort of two thoughts about that. The first sort of goes to that concern, which is I wonder if you don't go a little bit too far in revising our understanding of Myers to present it as sort of non-Unitarian, right? So one of your main arguments, both in the draft and in your remarks, for the sort of progressive bona fides of Myers is the carve-outs, right, that Taft gives us at the end, and in particular, the Taft's sort of disclaimer that this, of course, won't undermine civil service reform, right? But you know, as McReynolds sort of frames his dissent around, right, it's a little hard to take that seriously, right? It's hard to actually fit that with what Taft says in the opinion itself about why he's coming to the conclusion that he's coming to. So this then makes me think maybe there's an alternative reason for the carve-out for civil service reform, right? So one thing that puts me in mind of is that civil service reform has sort of successfully entrenched itself because, as Steve Skowronek has shown, right, it allows presidents of both parties to sort of entrench their co-partisans in power by appointing them to non-classified civil positions and then classifying those positions as the presidents are heading out the door, so that effectively you have this transitional moment, the first 3 to 4 decades, really, of the Pendleton Act, where, in fact, it's not that you get this sort of transition from the 19th century patronage presidency to a 20th century civil service presidency, but rather that you have patronage continuing by other means, and one of those means is precisely the Pendleton Act, right? That you can appoint your co-partisans to office and know they won't be displaced by the next president, because the next president would have to use the civil service exam to replace them. So if that's the case, then maybe the carve-out in Myers is actually sort of less about an ideological commitment to the civil service and to sort of the way that undermines the progressive presidency, and more about bowing to a sort of important and attractive to someone like Taft political reality. The second sort of point I wanted to just make about this paper is I think it would be helpful to engage more with Bowie and Renan above the line and not just below the line, right? So your paper, I think, is a really interesting complement to theirs. At least that's how I read it, right? So you focus on sort of structural goals. That is sort of what sort of governing arrangements various actors want. Whereas they show how those structures were in the service of a particular substantive agenda, which is to say redeemer ideology, right? So where when you note that sort of Taft, in between his presidency and his chief justiceship, devoted himself to a defense of judicial power in his academic writings, or when you note that Taft's legalism sort of accommodates a powerful presidency, Bowie and Renan then come in with an explanation for sort of why that is, right? Which is that Taft was engaged in the Redeemer project of rehabilitating Andrew Johnson vis-a-vis Reconstruction Republicans in Congress, which then sort of entailed fantasizing in some sense about an alternative history in which the courts had backed Johnson and therefore perhaps allowed Johnson to sort of win his fights with Congress. In other words, sort of Taft thought that the world would have been better if Myers had been the sort of accepted constitutional position in 1867, 1868, and he took the opportunity in 1926 to sort of write out that fan fiction, right? I think perhaps sort of tying these two really interesting, exciting projects more closely together might be helpful. Okay, last but certainly not least, Aaron and Chris's paper. So once again, I really like this piece, and once again, it's sort of calibrated to sort of appeal to all the things I care about, right? So anything that focuses on the ways that Congress can sort of unilaterally push back on the other branches is like catnip to me. But I do have, again, sort of a few questions about the precise mechanisms that you're relying on. So it seems to me in reading through the piece, there were sort of two broad families of mechanisms, or two sort of principal, I think there's a lot of sort of ancillary mechanisms that are important, but two sort of things that a lot of the attention was focused on. And one is the sort of one that you gave as the prototypical sort of hard power, which is essentially a set of mechanisms that make it harder to confirm a replacement, and therefore, sort of as you present it, more likely that a president will hesitate before removing an incumbent, right? This is the sort of, you can remove but not displace, because displace involves replacing. But I think there's sort of a couple of things in there that need more time spent with them, right? So one of them is something that you do mention that I'd like to sort of hear more about, which is the actings regime, right? Because we have just an incredibly porous actings regime, and it vastly reduces the costs of going without a confirmed replacement, right? We've just come out of an administration that governed almost entirely through actings, and while no one would say it governed well, I'm not confident that the reason that it was unable to govern well was actually because it was relying on actings, right? We've sort of, and this is not a sort of Trump administration specific phenomenon, right? The reliance on actings has been going up significantly over time. As you know, Ann O'Connell is the sort of authority on this, but it's just not clear that given the current sort of actings regime, the need to get a Senate confirmed replacement is really as significant as you suggest. And your mechanism sort of threatens to make that worse, right? So if you return to a supermajority cloture regime for confirming some of these officers, it's going to make it harder to get them confirmed, which is going to put more pressure to rely on actings, which is going to sort of further normalize the actings regime. Second, specifically in dealing with multi-member boards, a president could accomplish an awful lot of his or her sort of ideological goal by getting rid of an officer and not worrying about a replacement, right? If you've got a board that's split 4-3 and you can fire 2 of the 4, now it's split 3-2 in your favor, right? So it may not be in many cases that they even need to get or want to get a replacement confirmed if what they want to do is change the ideological composition of a multi-member board. Now, you do suggest, right, in your sort of discussion of anti-evasion regimes, that these are the kinds of problems that could be solved by legislation that the Supreme Court is likely to uphold. Now, I don't necessarily share your faith that the Supreme Court would remain pro-Congress if that ever actually required it to do anything that might empower Congress, but let's put that aside for a minute. The problem here is that essentially what the court has done is sort of come in after a whole bunch of legislation is on the books and then sweep out a lot of the assumptions on which that legislation was premised, right? So if Congress had been able to foresee when drafting various organic statutes or when drafting the Vacancies Reform Act or other things like that, that Humphrey's executor was on the chopping block, it could have adjusted for it in various ways, right? So it could have potentially limited the availability of acting officers. It could have adjusted quorum requirements for multi-member boards, things like that. And it could have done it in these organic statutes that a president was likely to sign because after all, they were creating these new agencies that the president wanted. But because Congress drafted these statutes against the backdrop of the permissibility of statutory tenure protections, and it sort of structured the agencies and delegated their authority accordingly, it sort of struck the balance that it liked at that moment. But now, when the court comes in and smashes tenure protection, Congress is going to find it nearly impossible to install sort of new anti-removal statutory mechanisms, because the president's going to veto them, right? This doesn't require sort of relying on separation of parties logic, right? You could have a situation where the same party has significant majorities in both the House and the Senate, where the legislative filibuster is not a problem for one reason or another. But if you're coming in with a sort of standalone statute that's putting limitations on presidential power, or correspondingly sort of enhancing congressional power to, let's say, persuade presidents not to remove, it's not clear what possible reason the president would have for signing that into law. Now, you can try to bundle it with sort of other things that are closer to sort of must-sign provisions, right? But the obvious moment to structure the agency that way is when you're first creating the agency, and essentially what the court has done here, as I think it's done in a number of other areas, is say, well, you drafted against the backdrop of these things, but surprise, they're gone now. Oh, well, if you want to change it, you can, right? Sort of ignoring the fact that the veto makes that nearly impossible. Okay, so those were sort of my thoughts. As I said, these are three incredibly rich and really interesting papers, and I'm excited to talk with all three of you more about these projects. But for now, what I'd like to do is, first of all, invite the five of you to talk to each other sort of briefly if you have any thoughts on one another's papers, and then also invite the audience to get involved. So we have a few questions in the queue, but just a reminder to everyone that if you have a question, just type the letter Q into the chat, and I will call on as many of you as time permits. So first of all, let's just sort of open it up to the panel themselves.
I just a small quick thought, which was in response to Chris's super provocative paper. It just reminded me, I think there's an episode in the early Republic where Washington has to go in front of a court to give reasons for why he can raise the army to intervene in putting down, I guess must be Shays, right? Or am I getting my I'm not an early Republic guy, but so
Whiskey.
Thank you, Josh. Whiskey. So it's just, Chris, I love when you said, boy, the reason giving requirement, and like, yeah, sure, not as good as an Article 3 trial, but it's better than nothing. I started thinking, wait, actually, right, there's like a whole alternative history where the reason giving requirement really did go into Article 3. And that then I think put Pavin's story in another light, right? Like if we think about the avoidance question against the backdrop of a world in which it just would have been routine for Article 3 judges to have to make decisions about whether the executive was giving reasons as Congress had required, it makes me think about, thinking about Josh's point about contingency and path development, path dependency and doctrinal institutional development, that idea certainly seemed to be there in the first Congress and could have gone both in terms of courts and in terms of doctrine in a totally different direction.
Josh, would you like the panelists to respond in order to your comments, or should we just sort of fire?
I just think if you have any, I definitely want to make sure we have time for audience questions, but if you have anything you want to say, I wasn't thinking a particular order. Just jump in.
Well, I'll just talk briefly then, since I butted in. I love both the other papers. I learned so much from them. They're so empirically rich, so that's always fantastic. I just had a question for Chris for that paper. Maybe predictable, right? But is the buzzsaw of the unitary executive threatening to swallow up the smaller anti-removal tools? Because I don't see really a limiting principle that would protect those, even if they're sub-statutory or something like that. The other thought I had was definitely in the separation of parties, Pildes and Levinson mold, right? That Congress is going to be using these tools, right, to impose, transparency requirements on firing. But I think part of the problem where we are, as a nation when it comes to constitutional law is that Congress's own motives are deeply partisan as well. So like, who really is the defender of Hamiltonian stability of administration today, Okay, so a little bit of pessimism there, but I just wanted to respond really quickly to Josh's points. I mean, I think big picture, I think you gave us sort of 3 suggestions, and the answer is we will adopt them all wholesale. Engaging with Bowie and Renan, 100%. One of the things that's not super emphasized in the paper yet is that Taft has this sort of horror of the legislature, partly because of how poorly his party treated him when it came to tariff reform, but partly we think because of the Bowie-Renan story that he sees Congress, from this redemption point of view. Are we making Myers too progressive? I think there's a real tension in the opinion that you get at. I think the rule that Taft lays down, a constitutional rule about what Article 2 requires, swallows up administrative independence, though Taft fights tooth and nail to protect these, entities. And I think today's court proves McReynolds to be kind of prescient there, right? The rule sort of has been appropriated as opposed to the concrete holding. And then finally, yeah, totally, exposing the political interest behind the Myers holding. No one knows this because I've talked about it ad nauseum because I think it's fascinating. There's a partisan story at work in the 20s, right? We think of the Democrats, we think of Woodrow Wilson as a progressive president, but this is actually Skronik building a new American state. Under the Wilson administration, the Democrats fundamentally returned to a spoils system. And so for Taft to assert administrative independence is not, again, just a progressive president with an independent civil service. It is also a slash at the Democrats, who are now seen to be the post-Jacksonian party of anti-meritocracy. So thanks for the comments. They were all fantastic.
Okay, I think why don't we go ahead to audience questions? So the first question is from, I don't know who this actually is, but NSC.
That's me, Josh. This is Nathan Chapman at the University of Georgia, and I'm now, I think I should be on the screen. I don't know if you can see me or not. I can't. Okay, cool. Yeah, this question is for Andrea and Noah. I really enjoyed the paper a lot. I learned a bunch. Right now, it feels to me, and I know you're kind of trying to figure out how to mash it into a final product, but it feels like a history of Myers, basically, with a kind of originalist hook. And I can imagine the originalist hook going one of a couple ways. And I think either direction you take it, you want to engage a little bit more than you do with the originalism theory. So one would be Myers isn't really an originalist opinion. For better or worse, now we have a robust and burgeoning literature on what counts as an originalist and not an originalist opinion. Is our law originalist, that kind of stuff. So Will Bode and Steve Sachs have written a lot about this. I don't buy everything they say, but there's, like I said, there's a lot of out there discussing that at a theoretical level. And then the other trajectory it should go, and Andrea, it sounded in your comments at the end that you wanted to make the claim that Myers not only is not an originalist opinion, but that it just doesn't square with the Unitary executive doesn't square with the originalist understanding of separation of powers. And I think to do that, you probably ought to engage with the latest theory on how originalists think about liquidation and the clarification of vague or ambiguous constitutional provisions over time. So I suspect that they wouldn't necessarily be convinced by the view that just because this wasn't settled as of 1787, it's inconsistent with the original understanding. So those are just a couple of little points. And it may be that, the originalism angle isn't really what you want to focus on, in which case, no reason to do any of that. So thanks.
Should I respond to that, or are we collecting questions?
I think if you want to go ahead and respond. But.
Okay, I'll respond. It looks like Noah unmuted himself, so I'll be super brief. I totally take both of Nathan's points, and again, this point about how much we have to engage with originalism. Initially, we wrote this paper, let's stay solidly in the 19th and early 20th century, but obviously the normative aspirations require deeper engagement with that literature. So thanks very much. What we would try to say is that yes, liquidation is considered part of originalist interpretation. That said, it has to be consistent with the originalist separation of powers. And so our claim is that the presidency, the popular leadership wielding administration governing president of Myers is unoriginalist. That's what we'd say. So liquidation can accommodate development, but it still has to be compatible with the text.
Noah, did you want to jump in?
Just maybe to say a small thing, and this is sort of a recurring puzzle for me as originalism goes through ever more epicycles. I was just teaching this in my constitutional law class to the law students, and it just drove home how originalism has evolved from, I think back when Raoul Berger was pushing it, a kind of approach to fixity as part of a distinctive political project in reaction to, in sort of its latest iteration, something almost more like a philosophy of meaning that has like this kind of linguistic set of considerations. And so one puzzle that I have as Andrea and I have continued to wrestle with this project is, which originalism are we interested in engaging with? And I thought the way that Andrea framed it is just exactly right, that this is ultimately a story about the meaning of the law and the development of these institutions, not necessarily joining a philosophical debate about the horizon of possible legal meanings and what happens in a world of fixity. So I really appreciate your suggestion, but I think part of what you're putting your finger on is that as originalism, as a sort of project of a legal academy enters its Rococo phase, the meaning for scholars who aren't committed to it becomes more difficult to pin down, and what it means to engage with it is less clear. But I do really appreciate the question.
Okay, our next question is from Gerard.
Hi, I enjoyed all the papers. This question is for Andrea and Noah, simply because I know a little more about the subject of their paper, so I feel like I can ask an intelligent question, maybe. To your mind, is Myers the source of the idea that the decision of 1789 is a proper noun, capital T, capital D, capital O? Because I ask that because while that precedent was discussed, from what I recall, in 19th century debates, Jacksonian era Reconstruction, about the removal power, I don't really remember anyone kind of referring to it as sort of anything more than just a precedent, one of many that were in the mix. At some point, though, it became canonized as the decision, right? And I'm wondering, did Myers do that, or had it already happened? And when did it happen? Any thoughts you might have on that? Thanks.
So let me just jump on this because I love this question. So I think the answer is sort of no, but with an asterisk. So it looks like, as far as I can tell, even starting in the 1830s, you've got people who trot out the debate about the creation of these government departments in 1789 as a set piece of argument around separation of powers. And I can't remember if they explicitly use the phrase decision of 1789, but by the time we get to the Myers opinion, the arguments about what we now call the decision of 1789 have been rehearsed so much in court that they're basically just a set piece. So even in the Shurtleff opinion, you've already got a recapitulation of basically the entire majority opinion that Taft will write about the decision of 1789 in Myers, but just I think it's certainly in the lawyers' arguments in Shurtleff, and it appears in other places in the writing as well. And like I said, it also goes back, even I think in the initial 1839 case, you've got people making the argument. What's interesting, I think, about it in the Myers case, though, is where it goes from an argument that lawyers are trying to use to go back to the colloquy between Nathan and Andrea a minute ago, some sort of authoritative liquidation. So to sum up the answer, it's around before. It's around before so much that by the time we get to Myers, it's already trite. But Myers is the case that kind of makes it seem like it's now authoritative. And that and certainly post that, I think people look to Myers as the authoritative source, and that earlier history of rehearsals seems to have been occluded.
The transition of language from debate to decision is telling, though. It'd be interesting to know when exactly that happens. Next question is Shalem.
Hi, thanks, and thanks for all three papers. Were really interesting. I also had a question I have a question for all of you, but I will limit myself to one, as I'm an organizer and I should listen to my own rules. So my question is for Andrea and Noah as well. And it's really about the relationship between the APD literature and doctrine. And so I've kind of always struggled to understand the relationship between the two literatures. Like, what do you do with the APD conceptions, and what does it have to do with doctrine, if anything? And the way I kind of think about the APD conceptions is just kind of historical best ways to explain complex phenomena and give them names so that we can talk about them. It's partly descriptive, it's partly kind of normative. But it doesn't translate neatly to me towards what we should say about what doctrine is. And so at some point you said that Myers constitutionalizes the progressive presidency. And I didn't really know what you meant by that, because it seems to me that, you know, there's a lot of things that would be consistent with presidential representation and presidential administration in terms of how to control the executive branch while also maintaining some sort of level of control for Congress. And Myers is just one particular package of control. So removal is just a tool, right, of controlling the executive branch. And the way the case came up to Myers, it turns out it's about, does the president have control over removal of principal officers? And the package that Taft lays out is, we're going to have unlimited removal of principal officers, but I'm going to leave open the idea that you would protect subordinate officers. I'm even going to leave open the idea that Congress can give statutory authority to subordinate officials that they can exercise without presidential input or control. But you could easily see a kind of opposite package being like, we're going to limit removal, we're going to allow limitations on removal for principal officers, but the president has full control over what subordinate officials will do. Congress can't vest statutory authority in a subordinate official without giving the president the power to do that. And I think you could say that both of those are consistent with presidential representation and presidential administration. And if that's true, I guess I just wonder about the ultimate payoff being like Roberts, if you want to take the unitary executive, it's a full package. You also got to take the ability for Congress to shield lower level officials from the president. Because if it's all just kind of contingent and we're just balancing ways of getting at these kind of vague abstract goals, then we have other ways to do that. Roberts doesn't like any of those. And so I'm not sure he's going to feel like compelled to take the package deal that you lay out as part of Myers. I'm not sure if that's coherent, but that's kind of me trying to struggle through the relationship between the APD concept and the doctrinal implications. Thanks.
Yeah, I don't know that I'm going to do justice to this question. I mean, it's a very nuanced question, and I think we probably should have a larger conversation about APD and doctrine. I mean, one like sort of nutshell of your question, I think, is APD giving us like determinate enough inputs that translates into a particular doctrinal holding, maybe? But I feel like you could answer that question a lot of ways. I mean, what we've tried to do is sort of a like institutional biographical approach, you know, because Taft, we know, was such a central figure in writing this opinion. So Robert Post at Yale has done an extensive history of the Taft court and talks about the process, how Myers was written. So like Myers really was kind of Taft's baby. So for us, we think it's pretty determinate that, you know, he was president, did struggle with Congress, all of the redemption history, that kind of thing. We also sort of detect in Myers, again, it's overwritten from our point of view, right? You could get to a narrower holding on statutory grounds. There's all this language about the proper role of the president, right? And so our contention is kind of that script of office, as we put it, that role is what you find sort of codified by the APD experience. Again, I think there's a lot more to unpack there, but I guess that's a sort of shallow answer to what you're putting before us.
The next question is Christine, but actually before I turn to her, I just want to, just on that precise question, I think one way to think about the relationship, I don't know if this is what Andrea and Noah have in mind, but one way to think about the relationship is simply that doctrine is one of the things that APD is trying to explain, right? The courts are sort of players in the project of American political development. And so just as it's, you know, they are sort of one of the inputs into the sort of developmental pathways that APD is working with. Christine.
Yeah, thank you. I really enjoyed all the papers, and I'll ask a question for Chris and Aaron. And I was curious about your idea of reason giving as a constraint or an anti-removal power. So the idea the president has to state causes when someone is removed, or perhaps another executive actor has to state causes. I think in a lot of cases, you might not hear about a removal. Instead, that's all kind of behind the scenes. You hear that somebody has resigned and there's no public removal decision. And I just wondered if you had ideas on how the reason giving would play out in those circumstances where there's kind of a behind the scenes understanding that someone will resign, submit their resignation letter. So there's not that kind of sidesteps, I guess, the occasion to give reasons in some of those instances.
I think I'll take, excuse me, I think I'll take this one. I think that's a totally fair question. I mean, but I guess two things. First, it's remarkable that reasons even work. Reason giving really works. And there's an awesome debate about this in the 1860s, where some senators say, this is the dumbest idea because obviously the president can just give any reason. So why do we even care about this? And then the other said, no, all we have to do is it's a signal to the president that he knows that we care about this and he's not going to remove them. And it turns out over the last 160 years, no comptroller has been removed, which is kind of awesome. But then to your specific question, Chris and I went back and looked at all the comptrollers, and there were some that submitted their resignation. And I think that fits within your model, which is sometimes the president will just lean on somebody or someone else will lean on them and they'll go away. And that's an answer that I think is true for the independent agencies as well, though. You'll look at some of Trump's holdovers. President Biden has essentially just kind of leaned on them and they have left. I think that's not unique to us. I think that's a problem for everybody. And Chris kind of alluded to at the end, one thing we like about this paper is there's an empirical debate in the poli-sci world about whether independence really even matters at all. And we've been talking about this forever, but maybe it doesn't even matter. And this is a way we can test that. If Congress really cares, Congress can do these things. But if Congress doesn't care because it's always been this way, and it's just lawyers have been talking about it, but no one actually, it doesn't really matter. Well, that's actually useful information as well.
So we have time for one or two more questions. I don't think there's anyone else currently on the queue, but Andrew.
Hi, thanks to all the panelists. These are terrific papers, and thanks to Josh for your very stimulating comments. I have a question for Pavan, which I'm going to try to formulate coherently here. The paper, it seems to me like an important part of the argument hinges on the idea that separation of powers avoidance is causing distortions in the process of separation of powers negotiation between the legislature and the executive branches. And I'm wondering if the concept of distortion in this context presumes some kind of pristine struggle between the executive and the legislature, which is being distorted by separation of powers avoidance, some kind of process governed by a sort of invisible hand logic that we should expect to produce optimal separation of powers equilibria, and whether in fact you think such a process exists and is being distorted by separation of powers avoidance, or and if so, what is your basis for thinking that? I apologize, not very coherently formulated question.
I think that you're right, that part of the purpose of this paper is to say that these distortions are seeping their way into negotiations between Congress and the president. I don't think that there is a pristine sort of form of argumentation between Congress and the president, but I will say that there are lots of areas where Congress and the president negotiate over the scope of, I'll stick with the theme of what I was talking about today, the scope of discovery that's going to be turned over, or what, how far the White House is going to cooperate with congressional oversight, just generally. And if that is taking place against the backdrop of constitutional principles that have a judicial overlay on top, then it's seeping in. It doesn't mean that there is a pristine answer, but that maybe the baseline between Congress and the president is somewhere different from where they've been negotiating thus far.
I guess my question is just, why should we think it's a problem that that these judicial decisions are seeping into the process of interbranch negotiation if we don't have a basis for thinking that the process for interbranch negotiation is one we could have confidence in absent this kind of judicial distortion? Like, what is the basis for thinking that the outcomes would be better the outcomes of interbranch negotiation would be better in the absence of this distortion than with this distortion.
So I think all three of the papers today recognize that there's some problem with the powerful presidency and where it's getting, and the role that courts have sort of been playing in empowering the courts to get there. So the purchase here is to say that there is constitutional dialogue and negotiation that happens outside of court all the time, and that we're using judicialized language there anyway. And so I don't have a precise sort of, in this case, we see that there's a problem, but we've been seeing, as Josh alluded to in his comments, like lots more resort to going to court because Congress and the president can't quite reach consensus on where they're supposed to be, which means that the executive is at least taking the aggressive sorts of positions that Congress can't find are actually reaching an accommodation that would permit the two branches to move forward together without interference from the third. And so my reason for thinking that shifting the paradigm, shifting the baseline would have maybe provide a difference is that right now accommodation is not working the way that it's supposed to be.
All right, and our final question goes to Noah.
My question is also for Pavan and just follows up on this line. And I was thinking a ton about the relationship between, whether the question of separation of power avoidance, whether the distortions are related to particular areas of doctrine or not. I guess what I mean is, does the question of distortion come up more frequently in some contexts or others? And so the example you gave for us is one where it's really clear how the SOP issues are going to be front and center because it involves this conflict between the branches. But I started thinking about other areas of law, and I was thinking, wait, hold on, wherever there's a question of deference, you've got sort of a subtle question of separation of powers. So even in like a Commerce Clause dispute, there's really a separation of powers issue about the role of courts, which means that maybe the same sort of distortion effects would come in. And so that made me think, wait, hold on. You know, you said a minute in your presentation, you said, Noah, once you start to see the distortion, you can't unsee it. And then I started thinking, wait, so does this mean, Pavan, that you're seeing it everywhere? Or are there some areas of law where we see it more and other areas where we see it less?
So I think we do see it more in some areas than in other areas, but yeah, I see the distortion of law through like a case or controversy system in the courts. I see that everywhere. That is sort of like a larger thing that I see of having judicial review and determinations that way. One part of my research that I'm focusing on now has to do with removal cases. And in particular, I think in Salo law or in Humphrey's Executor, the court says that for standing purposes, if you are challenging removal, you have an easier time getting in the door. You don't have to prove that it would have affected the determination in your particular case in order to get in the door. You just have to prove that absent this, that this removal was unconstitutional. That has to be the claim, or the structure, the administrative structure is unconstitutional. That's what you have to prove to get in the door. By contrast, for congressional standing, there is a higher threshold in place to get Congress in the door to be able to challenge some sort of conflict that it's having with the president. And so I'm interrogating now what this means for why we have so many removal cases and relatively few other sorts of conflicts. But I'm focusing on separation of powers, but you're right to point out that this distortion is sort of endemic to having a case or controversy model that is also a law declaration model.
Well, with that, we are basically at time. So I just first wanted to thank Pavan, Andrea, Noah, Aaron, and Chris for 3 really fantastically interesting and generative papers. And I'm excited to see how all of these projects continue to develop and to continue to talk with them about it. And also thank you to all of you for turning out and for your excellent questions and comments. Thanks, everyone.
Thank you, Josh. Thanks, everybody, for turning in for the great questions. Appreciate it.